بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وأهل بيته الطيبين الطاهرين اللهم صل على محمد وآل محمد وعجل فرجهم. Now, before we begin this maxim, which is, I call it criminology. This is, it's about murder, so this is somehow a criminology. Yesterday, Dr. Ali, you asked me, what is the difference between al-usul al-amaliyya, the practical principles, such as the asl, the principle of bara'a, the principle of ihtiyat, caution, the principle of continuity, istishab, and others, and a maxim. And does a maxim always take over? This is hukuma. Overrides a principle, or sometimes it overrides a principle. Are you with me? Do you remember? Is the question clear? Does the maxim, jurisprudential maxim, does it always, when they clash with al-asl al-amali, the practical principle, such as istishab? Let's take istishab, continuity. Does always this one override istishab, or sometimes istishab could override, or another principles, usul amaliyya, can override? Do you remember why we resorted to al-asl al-amali?
When you don't have a specific...
What?
A specific
Evidence.
Evidence, exactly. When you don't have a specific evidence, not that it could be there, but you can't find it. You could not find it. It could be there, but our knowledge is limited. We are not at the time of tashri' legislation. We are not with the Prophet. We are not with imams. We are past that, many hundred years. So now there could be some evidence for a problem. We can find some evidence, some solution, but we might not be able to find it. So in case we could not find it, then we resort to al-asl al-amali, because al-asl al-amali always pops up when there is no evidence. In the maxim, do we have evidence or not?
Yeah, you have to.
We immediately after we put the title of the maxim and the definition of the maxim, we put the madrak. Madrak, and sometimes it's Quran, sometimes it's riwayah, sometimes it is tasalum, the consensus of all fuqaha, tasalum. Sometimes it's aql, siratul uqala. So when there is madrak, the priority goes for the madrak. The one has madrak. And all maxims, they have madrak evidence. They are based on evidence. Why do we have maxim? Maxim, it means that we found a hadith which outlines for us a broad or general rule that could be applied in limited cases or many cases, numerous cases. Such as the one we did last night, al-haylula. That is limited. It's only when the time of the prayer expires. But there are others, asalatul sahha, asalatul tahara, asalatul hil, many others that can be applied generally, widely. Because we have a madrak. So once we have a madrak, always when you have a madrak, it overrides the principle that does not have madrak. So this is why, Dr. Ali, does the maxim always override the principle? The asl al-amali, practical principle, always?
Yes, if it has a madrak.
It has to have a madrak.
Yeah.
If it doesn't have a madrak, we cannot call it maxim.
Right.
We call it maxim, a maxim, qa'ida, because it has a madrak.
So, right.
Qa'ida is based, the maxim is based on a madrak, on an evidence, on an ayah, on a hadith, riwayah. So this means that when we have a maxim, then the term does not even come to the practical principle. Practical principle is much lower. Now, what is the strongest among the principles, practical principles, usul amaliyah? Which one of them is the strongest? And it is widely used, and it is one level underneath the amara, or the evidence that we have.
Aq?
No. Asl al-amali is what?
Purity? The purity?
No, not maxims, not maxims. Principles that we studied in the usul. We studied in the usuls that when we cannot find an evidence in the Quran, in the hadith for this problem, then we can apply certain principles. One of them is bara'a. Bara'a, it means that you have no responsibility. So practice this, eat this. Or ihtiyat. Ihtiyat, it says no. There is some sort of ilm ijmali. Ijmali is not detailed, non-detailed. So there is some ilm that there is hurma, prohibition, so you should not touch. Though the ilm is not detailed, but still there is ilm, so you cannot breach that. You cannot throw it away. Okay? So here you have to apply which principle? No.
Oh.
Ihtiyat.
I'm sorry.
Ihtiyat. Caution, which is the opposite of bara'ah. And then we have istishab. Istishab is to continue the previous condition or the state. The previous one. Okay? They say istishab is the strongest one. Strongest one. But still that strongest principle, when it is compared with a maxim, it cannot stand. Because maxim is based on madrak, a madrak that is acceptable, powerful, acceptable, dependable, reliable. So that's the difference I wanted to outline before we begin tonight's lesson. Tonight's lesson is Damul Muslimi la yadhhabu hadaran. The blood of a victim Muslim who has been killed, doesn't go in vain. It would not be lost. What does that mean? Speaks about the importance of the blood, the sacredness in Islam. Islam applies value to the blood of the victims. So if we find someone who has been murdered, and we have some suspects, and the suspects are arrested. They are taken to the court, let's say. In the court, the plaintiff stands and he says, I think those are, 1, 2, 3, 4. Those are the suspects. The plaintiff, and we have the defendants who are the suspects. Okay? Two sides. The plaintiff does not have, what is the rule in the court? The basic rule in the court.
Innocent until proven guilty.
Definitely. But in case the plaintiff stands in front of him and the defendant, what is the first thing the judge is going to ask the plaintiff?
Your evidence?
Exactly. Al-bayyinatu ala al-mudda'i. This is the rule. Bayyina means the evidence is upon the plaintiff. Do you have bayyina? Do you have a witness? You're accusing this. You are suing him, accusing him. Do you have a witness? Al-bayyinatu al-mudda'i. So if he has bayyina, a witness, and the witness is strong, they cross-examine the witness, maybe more than a witness, in certain cases 4 witnesses, and some of them 2 witnesses, and they go through examination, then who wins the case? The plaintiff wins the case. If the witness does not have bayyina, then the turn comes to what? The second stage. To what?
If the plaintiff does not have it?
Yeah.
Confession.
No. Confession, that if the defendant confesses from the beginning, then we don't even need a witness. That's it. He solved the problem for us. Jazahullah khair. But sometimes he doesn't confess. So if the plaintiff does not have a witness, bayina, evidence, what is the second? What is the judge going to do next?
Qasam
Upon whom?
on himself.
No. البينة على المدعي, the evidence is upon the plaintiff. واليمين, the qasam, على من أنكر, the defendant. The defendant has to do qasam. The shar'i qasam.
Oh, the defendant has to do qasam.
Yeah. Now, if the defendant did not do qasam, he said, I abstain, then who's going to win the case?
The defendant.
No, the defendant did not do qasam.
Oh, he denied it.
Denied it.
And the plaintiff.
The plaintiff. Or then the third stage, it could be that the plaintiff does the qasam. So if he does the qasam, again he will win. Okay?
Even if they both give qasam?
If the defendant did not do qasam, but still the judge is not quite, convinced that he is the perpetrator. So he might ask in the third step the plaintiff to do the qasam. Now, if all we went through these stages and there is no winner, the judge could not prove that the defendant is guilty, or the defendants, either one or many, are guilty. What do we do in this case? He could not. They put him in jail for 1 day, 2 days, 3 days. The plaintiff could not bring an evidence. The plaintiff did not do qasam too. Okay? And let's say the defendant, he did the qasam, it's not me. But there is a murder, there is a case. What do we do in this case? This is a criminology class. I'm training you to be judges, inshallah, without going to law school.
So just to review, so you have a dead person, no evidence.
Mm-hmm.
We went to the second stage, the defendant doesn't do qasam,
Mm-hmm.
and the plaintiff.
No, the defendant did the qasam, it's not me. It's not me. They were captured. The plaintiff did not have witnesses. The defendant defended himself by doing the qasam that it's not me.
Okay.
Shar'i qasam.
Uh-huh.
It's not me. I'm not guilty.
Okay.
He pleaded not guilty, like here in the court. Pleaded not guilty. In Islam, pleads not guilty by saying, Wallah, Billah, Tallah, it's not me. I didn't do it. Then we go back to let's say, to the plaintiff. Plaintiff, whether he does the qasam or doesn't do the qasam, still the judge is not convinced. Because the judge cannot, execute someone unless he's 100% sure.
And I know this is not probably the answer, but why can't we use maxim of Sahha, the one we accept?
No, we can't.
We can't use that here.
That one, when someone is a suspect, so you need more than asalat al-sahha to prove your innocence. More than that. You are a suspect.
Right.
Sometimes you are walking the street, yes. Someone walking, this is asalat al-sahha. I don't go after him. But if there is some suspicion, then you need something more. You cannot dismiss it with asalat al-sahha. You need something stronger than that.
Maulana, the qasam, if someone does it, he might not be truthful.
Yeah, but we apply asalat al-sahha. He might be lying, but what can we do? We take him by his, This is here, when you go to an interview, they assume that you are telling them the truth. To the immigration, to this, to that. They don't say, oh, this is lying. Oh, you are lying. They can't keep saying you are lying. Then it's not an interview. So in Islam, we have this, that if someone does religious qasam, then they take it serious. Nowadays, maybe they don't take it serious.
Yeah.
But
that's
they,
what I mean.
they
Like,
used to take it
would
serious.
they even give it the, doubt to it? I mean,
Now, to be honest with you, in Islamic courts, they are not using qasam anymore because they know people are taking it lightly. So, in this case, when there is no evidence, then the suspect has to be released and case dismissed. But what do we do about the blood? There is a victim. So, what does this maxim suggest? That the blood of a victim Muslim doesn't go in vain, it's not lost.
someone has to pay
Judge
the
has-
diya.
Huh?
Judge has to pay.
The
The
judge
court has to pay, the government has to pay.
to pay to the family.
To the family.
The government has to pay. Baytul Mal. Case is dismissed, but that does not mean that. So who has to pay? Here, Baytul Mal, the treasury, has to pay for the family of the victim. And that is applied. And this is the madrak, of course, we have many madrak. When it comes to this, different riwayat. One of them is Sahiha. Okay? Sahihat Muhammad ibn Muslim. From what Imam an Abi Abdullah al-Sadiq, Imam al-Sadiq alayhi salatu wassalam. Okay? He says, ليس عليهم شيء ولا يبطل دمه. ليس عليهم. Nothing is upon them. ليس عليهم شيء. Nothing is upon them. No liability. But ولا يبطل دمه. But the blood does not go in vain. It means we dismiss the case. There is nothing upon them. This is in answering to the question that a man was sitting among a group of people and then he died. And we don't know what causes his death. Among many people in the session died. We don't know. Nobody said, I murdered him. We could not find an evidence. Or a person is found in a qabila. He went to a village, qabila, and then he found dead outside the house, at the doorstep, sometimes inside the house. Then we have to investigate. When someone dies inside my house, then of course they take me to court. Tell me what happened. But outside the house, and then they take them to court, they sue them, and they could not find an evidence, then in that case they are released. ليس عليهم شيء, no liability. But the blood money, diya, does not go away. The blood money has to be paid. The diya is called diya, has to be paid from Baytul Mal. Okay? Now, and this case happens where? In many places, such as, I'll give you some example. إذا وجد قتيل في زحام الناس, in public, crowd, huge crowd, and someone is dead, lying on the floor. Laying on the floor. So this is one case. Or على قنطرة. قنطرة means bridge that crosses the river. Okay? أو بئر. بئر is the well, when people draw water. He's dead there. أو شارع عام. أو جامع, inside a mosque, someone. Or in a desert. Or these public places. Where we cannot find a specific person to blame. Public place. Could be anyone.
So this is murder, not regular dying.
Death. It could be murder by poison. Who knows? But we found him dead.
Or it could be
But
an
it's not,
accident.
but it's not natural causes. It's not a heart attack.
In the past, they didn't know, all of them, all deaths were treated at, one cause, and that is Israel alayhi salam. So there is no autopsy, there is no, who will care, he's dead. Inna lillahi wa inna ilayhi. His ajal arrived, and then yallah, carry him and bury him the same day. Who will, nowadays it takes, 3 months, they do autopsy, DNA and that. These are very simple rules which do not apply today. I don't think they apply. We study them, but we study this principle. The principle is good, that if after even investigation we could not find a suspect to indict, then we still are responsible. The state is responsible to pay the family the blood money. So this is one of the maxims. Let's go to another maxim tonight, and that maxim is called Qa'idatul Ihsan, wholesomeness. The maxim of wholesomeness or kindness, if you will. Kindness. Al-Ihsan. Al-Ihsan, which has been taken from the Quran. Where is it in the Quran? هل جزاء سورة الرحمن هل جزاء الإحسان إلا الإحسان فبأي آلاء ربكما تكذبان. This is Surah Al-Rahman, verse 60. Rahman. Ar-Rahman. Okay. Now, what does that mean? What does ihsan mean? Ihsan means that if a person with goodwill, good intention, an intention of helping, an intention of kindness and wholesomeness, tried to help someone, to save someone, to rescue someone, and accidentally he killed that person or he damaged his property. Let's say there was a fire in a house, and in order for that person to extinguish the fire and save the people of the house, he was a Samaritan, goodwill Samaritan. He damaged the wall, let's say, of the house. Is he liable for that? Is he responsible? His intention was good intention, to protect, to save, to help. But he did damage. He damaged the house. He damaged the shop. He damaged the car. Do we hold him responsible? What does aql say? Reason. Let's assume that he had goodwill.
Was he asked to do that?
No, he wasn't
He
asked.
just volunteered.
He passed by and there was an accident and he tried to help that guy. He runs him over, let's say. Or some people, they try to extinguish the car, the small damage, they go and damage the entire car, let's say. They do things like that, happen. He was trying to take this car from the middle of the highway to the sideway, to protect the driver, the family. While he was driving it, he was hit by another car. They died. Or the car is damaged. Do we hold him responsible? What does aql say? Bina'ul uqala. Aql. Aql means bina. Bina means bina'ul uqala. It means the foundation, the assumption of the uqala here. What does it say? Uqala.
He's innocent. He's innocent because
He's not responsible.
his action is not on purpose.
His intention was good, but outcome came out not good. So.
Even if he's not asked,
No,
he interfered without anyone asking him.
Oh, so what's then the kind of al-ittilaf, where it's
Al-itlaf.
itlaf? Yeah.
Uh-huh.
Isn't it similar?
They share some similarities. So what do you think? You think if nobody asked him, he interfered. He saw a dangerous situation, he tried to interfere with goodwill, but unfortunately, accident happened.
Well, then I think instance, and so there was something, he did this for a reason, thinking he'll help you.
Yeah, yeah, of course. His intention was pure, to help.
So,
But something, that, accident happened.
right. So I think you should be forgiving it. I know his intention was good, so you have to.
They say bina'ul uqala is that it's not right to hold someone responsible who had good intention to help. Because if you hold him responsible, people are going to decline. They are not going to be. They are going to be intimidated. And you are discouraging them from helping others. Beside this verse here, هل جزاء الإحسان إلا الإحسان? God says, isn't it that the recompense of someone who does good is good? Not you hold him responsible, tell him, come here, I have to punish you. Why did you do this? This is one. The second verse also, the second verse is more powerful in Surah At-Tawbah. The second one is 991, Surah At-Tawbah. Okay? ما على المحسنين من سبيل ما على المحسنين من سبيل. No liability against the virtuous. There should be no liability against the virtuous. When someone is doing good out of himself, okay? For instance, someone is paying $10 to you, free, not in return for a service, nothing. You cannot hold him, tell him, no, why don't you give me 15? He's giving you free, this is. You cannot argue with him.
They do that now.
Now they do. Okay? So whatever he gives, it's good for him, good for you. You don't have to, because this is not in return for a service that you argue with him, you bargain with him. Whatever he gives. Okay? ما على المحسنين من سبيل. And this comes in a verse, the beginning of the verse. God says, ليس على الضعفاء. No blame upon the weak. ولا على المرضى, neither the sick. ولا على الذين لا يجدون ما ينفقون, neither upon those who don't have money to help the army, to help the community. ما ينفقون حرج. There is no blame on them. إذا نصحوا, when they have goodwill. إذا نصحوا لله ورسوله. You don't charge them because he's weak, he's sick, he doesn't have money. You cannot hold him responsible and tell him why you don't give, or liable. ما على المحسنين من. The ayah ends with this premise, very powerful. ما على المحسنين من سبيل. The virtuous, you have no argument against them. You have no liability. You don't hold them responsible. The muhsinin, you don't hold them responsible. Though this ayah came in a specific mawrid, the occasion of descent of this was a specific, during a specific war, battle. But we said a very broad maxim. What does the broad maxim says? Al-mawridu la yukhassas. This specific occasion of the descent of this, because it came through a specific occasion, yeah? Specific occasion. Does not confine the ruling of it. Yes, it came through this occasion, but it does not mean that it's only limited to this occasion. It can apply to other occasions too. You can broaden it to other occasions and other events. Okay? So here, if someone does, then he's not responsible and not liable, and he does not pay for that damage. You don't ask him to pay for the damage that happened, took place. Okay?
As a result, a person dies.
Even if he
does out of
dies.
good intention,
Even, see, for instance, someone is drowning, and this guy, he rushed to help him. He rushes to help him. And his intention was to pull him out of the water. But somehow, this second person, something happened to him. He had muscle spasm. He was caught in the what they call it? Rip current, okay? And he could not, save him. The guy died. In the process of saving him, the guy died.
yeah, but if in the process he kills him, let's say he goes by a boat, hits the guy by a boat and the guy dies.
What was his intention?
To save him.
To save him, and then he hits him accidentally?
Yes.
Inna lillahi wa inna ilaihi raji'un. Same thing. His intention was to go there and pull him out. But somehow when he reached the boat, hits, the head of the victim. Unintentionally. But he went there to save, not to kill. But Israel said, no, I want him to die. Again, same rule applies.
So is the state responsible in this case?
The state definitely. This is another maxim. We come to another maxim that covers this. But we are vindicating that person who has goodwill. Definitely the state will pay for everything. But here, do we hold this person responsible or not? Now, examples for this, case studies. In some countries, the government comes, raids the house of this man, his mansion. They take him to prison. His neighbor comes and he tries to save, let's say he has cash money, he has jewelry, he has a car, he has, expensive items. He goes, he takes them with goodwill. He loves his neighbor. So before the agents would come and take this money, he will take these things to his house. He stores them in his house with intention of returning these items to this man in the future. Whenever it is saved, he will give him this money. Cash money, jewelry, his car, his computer, whatever. But then that house is burned in California fires.
Which one, the person that took the money?
Yeah,
His house.
yeah. His house is burnt. And everything inside the house turns into ashes. Or a flood, let's say a flood. There was a flood. This is an example. Do we hold him responsible? The man who was arrested did not ask him, please go to my house. No, but he saw that. He saw it, from his window. He said, well, he's my friend. I know he has money inside. He has jewelry, he has things. So before they come and take it, let me protect the money for him and give it back to him whenever it is saved. So what do we say in this case? Does it apply or doesn't apply? Dr. Ali, what do you think?
It applies. I mean, you don't have to give it back to him. He was storing it for him, so you can apply this maxim.
So we can apply them. If he lives in that house, because I know in some countries like Iraq, when they came to arrest, some people come and occupy the house so the government does not come and put its hand on the house. It happened to our property in Karbala back in 1971 when we left. Some people came and, they stayed in the house, so the government does not take it. And while he was living in the house was damaged. But his intention was to stay in the house until this guy, I can give it back to him. I am in this house to preserve it for him, to protect the house from being taken away. That was my intention. Not that I am homeless and I have no place, so let me go and take advantage. No, I am here. I make myself the tenant, so they don't come, if the house is empty, they don't come and confiscate the house. or put their agents, let's say, there. So my intention was good, to protect the house of my relative, my friend, my neighbor, my whatever. But the house was damaged while I was there. Whether natural or my children, they opened the pipe and the ceiling went down. What do you do in this case?
Well, if the intention, I think, is purely to keep things from getting confiscated in the benefit of the other person, then you can apply the maximum.
Okay. The third case is children who are underage and they have money and someone came to invest their money, mutajara, to invest, but he lost the money.
This is liable.
Liable? According to what maxim?
I don't remember the name of it, but it was one of the maxim.
Talk about the orphan.
قاعدة الائتلاف.
Itlaf.
إتلاف.
Orphans are an exception.
But
Itlaf, what did we say? We said whoever has the gain is going to pay for the loss. So if this man is investing the money and the profit is going to the kids, not to his pocket, he's not doing that for himself. His intention is ihsan, to help them. Why the money is sitting there in the bank? Let me work with the money, make the $10,000, make it $20,000. Ihsan.
But the legal guardian have to have an okay to.
Definitely, in this money, of course, he would not do that without the permission of the. How can he has access to that money?
Right.
But then there's very sensitive question. It was not cash money. It was a piece of land sitting there. Those kids, are kids. They can't do anything with this. So he said, let me invest. This is a land, left there. So I'll do, let's say I'll plant something in that land. But something happens, the land sinks down, let's say. Let's say something, an example.
As a result of what he did?
As a result, of course. As a result of his goodwill intention to not let the land sit idle, to make use of it, to benefit those children, he damaged the land. He damaged it. It needs repairs or it lost its value. What do you think as a judge? You are judges now, half judges, inshallah.
No, I think it's maximum applies. It's the same scenario now.
Same
Yeah, the benefit of the
scenario.
You say this maxim applies? This one?
Well, I mean, he's
Yeah.
not-
Is he liable or
he's
not
not liable.
He's not liable.
Yeah.
Yeah.
I would argue that he is liable, similar, regardless of if it's land or money, it's valuable.
But even we said the money, if he itlaf, we said when you go with a person, when you go to appropriate the money, you are taking it ghasb, not with the intention of helping that person. You're taking it for yourself, taking this shop, this house, this car, and you damaged it. You took it for yourself, ghasb, by force, not with the intention of ihsan.
But I thought orphans were exceptions. Orphans can't lose. They can never.
No. Even the orphans, with the permission of their guardian, either the guardian or with the permission of the guardian. The money was given to someone to invest and he lost. Because the benefit goes to them, they incur the loss too.
So even in the case of orphans, they.
Yes.
I thought we studied that orphans had an exception.
Maybe ihtiyat, maybe some scholars, because they say they are orphan.
Yeah.
Only that. But the general rule is that if you are benefiting them, the profit is going to them out of this investment, then they incur the loss too. وصلى الله وسلم على سيدنا محمد وأهل بيته الطيبين الطاهرين.